Donald Trump has faced a lot of courtrooms, a lot of judges, and a lot of rulings he didn't like. But rarely has he walked into a Supreme Court quite this nervous, where he's calling judges stupid, attacking two he personally appointed, and predicting defeat before a single argument was heard. Trump attended the court hearing on April 1st, 2026. And no, this is not an April Fool's joke. To listen to oral arguments in Trump versus Barbara. Don't think he attended out of judicial curiosity, but that's another story. The president already seemed to know something the rest of the country is still waiting to find out. The month of June can't get here any faster. Welcome to That's Life, I swear. This podcast is about life's happenings in this world that conjure up such words as intriguing, frightening, life-changing, inspiring, and more. I'm Rick Barron, your host. That said, here's the rest of this story. President Donald Trump has never been one to hide his anxiety behind diplomatic restraint. And in the days leading up to the most consequential Supreme Court arguments of his presidency, he made little attempt to do so. On Truth Social, he called the court stupid. He attacked the justices he himself appointed. He predicted the Supreme Court would reach the wrong conclusion. And in a all-sprawling, all-caps post, the day before oral arguments were set to begin, he declared that the entire debate over birthright citizenship was never meant for anyone other than the children of enslaved people. The Supreme Court convened on April 1st, 2026, to consider the legality of President Trump's executive order seeking to end birthright citizenship, marking a major test of a key pillar of his immigration agenda and the first time the High Court has weighed the legal merits of one of his immigration policies directly on its merits. The case is known as Trump versus Barbara, named for a 35-year-old pregnant asylum seeker from Cuba, whose circumstances became the legal flashpoint for a question that strikes at the very foundation of American identity. Who exactly is an American? Trump signed his executive order on birthright citizenship on the first day of his second term. The directive denies U.S. citizenship to children born to a mother in the country unlawfully and a father who is either not a citizen or a lawful permanent resident, or to a mother who has lawful temporary status and a father who is not a citizen or lawful permanent resident. The directive, however, has not yet become effective since its legality was challenged soon after it was signed and has been blocked by lower courts. The case that reached the Supreme Court represents the first full merits-based examination of whether Trump's order can survive constitutional scrutiny. Trump versus Barbara stands apart from the usual storm of immigration controversies. The Supreme Court placed this case on a very rare fast track, calling out just how deeply it cuts into the nation's core and how vital it is for the court to resolve the question without delay. Now, to understand why this fight is so combustible, one must understand what the 14th Amendment says, and more importantly, why was it written in the first place? The 14th Amendment to the Constitution came in after the Civil War and was aimed at reversing the Supreme Court's infamous Dred Scott decision, a ruling that declared black people, enslaved or free, could not be citizens of the United States. The amendment's citizenship clause states plainly, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. Drop the mic. Ratified in 1868, the right to birthright citizenship was affirmed by the U.S. Supreme Court 128 years ago and has been treated by courts, lawmakers, and successive administrations as settled constitutional law ever since. Now, as if to put the icing on the cake, Congress in 1940 passed a statute codifying birthright citizenship for any child born in the USA. The question before the Supreme Court now is whether the President's executive order violates the citizenship clause of the 14th Amendment and a provision of federal law that codified that clause. That statute was first enacted through the Nationality Act in 1940 and then reenacted in the Immigration and Nationality Act in 1952. Now, the president's legal argument rests on four words tucked into the 14th Amendment. Quote, subject to the jurisdiction thereof, end quote. Now, at the center of the case is that single phrase. The administration contends its order does not alter existing law, but instead revives what it sees as the original intent of the citizenship clause by denying automatic birthright citizenship to those it believes are not truly subject to the jurisdiction of the United States. In filing with the Supreme Court, Solicitor General D. John Sauer argued that the 14th Amendment was adopted to grant citizenship to free slaves and their children, not to babies whose parents are undocumented or in the USA temporarily. He said the interpretation that the Constitution guarantees citizenship by birth has been wrongly applied for more than a century, and the president is now seeking to correct that misreading. As a result of that prevailing view of citizenship by birth, citizenship has been granted to hundreds of thousands of people who do not qualify for it, Sauer argued. That misinterpretation has powerfully incentivized illegal immigration into the U.S. and encouraged birth tourism, in which pregnant mothers come to the country to obtain U.S. citizenship for their babies. In other words, Trump has been even blunter when he stated, and I quote, hundreds of thousands of people are pouring into our country under birthright citizenship, and it wasn't meant for that reason, end quote. In a Truth Social post, Trump declared, and I quote, birthright citizenship is not about rich people from China and the rest of the world who want their children and hundreds of thousands more for pay to become citizens of the United States of America. It is about the babies of slaves, he added. We are the only country in the world that dignifies this subject with even discussion. Look at the dates of this long legislation, the exact end of the Civil War, end quote. Now, there are clear signs that Trump believes he may lose this one. The president may be bracing for a loss in the birthright citizenship case, writing on Truth Social that the Supreme Court will find a way to come to the wrong conclusion. Now, Trump's post follows another one from the previous month that apparently sought to soften the blow of a possible loss of the birthright citizenship case. Fresh off his tariffs defeat by the Supreme Court, Trump wrote that the next thing you know, the court will rule against him on birthright citizenship. He added that the court will find a way to come to the wrong conclusion, one that again will make China and various other nations happy and rich. If the High Court rules against the Trump administration, it will mark the second major loss for the president in his second term. In a 6-3 decision in February of 2026, the Supreme Court struck down many of Trump's tariffs issued under an emergency powers law. Now, since that ruling, Trump has been critical of the judges, including his own appointees. In another Truth Social post, Trump called the court stupid. At a fundraiser, he alluded to Justices Neil Gorsuch and Amy Coney Barrett in saying two of the justices he appointed had let the country down. Now, if there is a single legal ghost haunting Trump's arguments before the Supreme Court, it is a man named Wong Kim Ark, a laborer from San Francisco whose case, decided in 1898, became the foundational ruling on what birthright citizenship actually means. Let me explain. In 1898, the Supreme Court ruled in the Wong Kim case named after a laborer who was born in 1873 in San Francisco. Now, his parents were Chinese and lived legally in the United States. Now, around the age of 17, Wong left to visit China and then returned to the United States without incident. Then around the age of 21, he left again to go visit China. But at the end of that trip, he was denied re-entry to the United States because the collector of customs argued he was not a U.S. citizen. This happened during the era of anti-Asian strictures known as the Chinese Exclusion Act. The Supreme Court disagreed, however, with the government's position and ruled in Wong Kim Ark's favor. establishing once and for all that a child born on American soil to foreign parents was, by the plain text of the 14th Amendment, a United States citizen. Now that ruling, again, has stood for 128 years. Now the case against Trump's order rests not only on the text of the amendment, but on its historical origins. During the congressional debates over the 14th Amendment, Senator Edgar Cohen of Pennsylvania raised the question of whether children of Chinese immigrants in California, or gypsies, wandering through Pennsylvania would be granted citizenship. The supporters of the 14th Amendment agreed with Cohen's assessment of what the language would accomplish, namely, that the mere fact of being born in the country can and would confer birthright citizenship. But the senator from California says something differently. I beg my honorable friend from Pennsylvania to give himself no further trouble on the account of the Chinese in California or the Pacific Coast, responded Senator John Conness of California. In other words, the very scenario Trump's administration seeks to prohibit, citizenship for children born to non-permanent foreign residents, was explicitly contemplated and included by the amendment's original framers. In 1995, the Justice Department determined that eliminating birthright citizenship would require a constitutional amendment. However, Trump has argued for undoing the right stretching back to his first administration. It was always told to me that you needed a constitutional amendment. Well, guess what? You don't, he said in a 2018 interview. Beyond constitutional debates, opponents of the order have raised urgent practical questions about implementation. If allowed to take effect, the policy would create a tidal wave of legal confusion and chaos, predicted Jill Hellberg, the CEO of Public Rights Project, a nonprofit that filed a brief in the case opposing the administration. Federal agencies have rolled out a series of guidance documents explaining how people would apply for passports, social security numbers, and safety net programs under Trump's plan. But some of those materials have raised as many questions as they've answered. According to a projection by the nonpartisan Migration Policy Institute in Penn State, if this law is struck down, that could result in about 255,000 U.S.-born children beginning life without U.S. citizenship every year. Children who would effectively be rendered stateless in the only country they have ever known. After oral arguments that took place on April 1st, a decision from the Supreme Court is expected to happen during the summer recess, which begins at the end of the term in late June or early July of 2026. Now, whether the court's 6-member conservative majority will hand the president the victory he wants, or add this to his growing list of judicial defeats, remains uncertain. We just don't know. What is not uncertain is how much Trump wants this particular fight resolved in his favor. You see, for him, birthright citizenship represents something deeper than immigration policy. It is a referendum on who belongs in America, who has the authority to decide that question, and whether a president can rewrite the rules of national identity with a single pen stroke. Well, in this case, a Sharpie. The framers of the 14th Amendment believe they had already answered that question, in ink, with the blood of a civil war still drying around them. On April 1st, 2026, 9 justices began the work of deciding whether that answer still holds. So what can we learn from this story? What's the takeaway? Trump has been pushing this idea since 2018, and 8 years later, he still hasn't succeeded. That's not an accident. The 14th Amendment was written with deliberate, sweeping language, precisely because its framers wanted to make it difficult to carve out exceptions based on who someone's parents were. Well, there you go, my friends. That's life, I swear. For further information regarding the material covered in this episode, I invite you to visit my website, which can be found on Apple Podcasts, for show notes and the episode transcript. As always, I thank you for the privilege of you listening and your interest. Be sure to subscribe here or wherever you listen to podcasts so you don't miss an episode. And we'll see you soon.